Good morning, everyone.
Oh, you have to make an entrance to the stage. And
if I could just invite you all to please take your seats so we can get started with the second panel. Thank you. So as I mentioned earlier in the morning, there is a framework within which practitioners working with children can ground their daily practice. And I wanted to share a little bit with you about what the framework represents. And for those of you who are familiar with this document, I hope you'll bear with us for those of us in the room who would like a refresher or perhaps even a first introduction to this particular document. I'm going to leave sort of the outline fairly broad, and then later when I join our co-panelists, Jessica and Pia, will be able to go into specifics. So you'll have time to explore how these principles can be translated into practical impact and outcomes in the work that we do. So starting off with sort of the overview of the presentation, I'll talk a little bit about the CRC provisions, and in particular then, what are the imperatives for incorporating these principles into the work as practitioners, and what some of the gaps are when it comes to institutional care for children. And I'm going to end on the best interest principle, which is one of the guiding principles that I hope that all of us can start thinking about and reflecting on what that should look like in the context of what we do. So, as you all know, the United Nations Convention on the Rights of the Child is an instrument which Hong Kong is a party to. It came into force in 1990, and very soon after, Hong Kong was a signatory by virtue of the extension of the United Kingdom's signing on to the document. At present, there are 140 state parties that are party to the convention. There are a total of 196 countries who could be a party to this particular convention. It is one of the more widely ratified conventions as well, but there are in some cases some notable exceptions that are made to the convention by different countries on various grounds. There are a number of rights which you'll find in this document. What I'd like to focus our attention on is really when you look at some of these types of rights, what are the things that come to mind? And one of the things that I often like to think of is that, they're all aspects which reinforce the developmental context within children, develop their individualism, their identity, their sense of self, and their agency, right? And so in particular, I've highlighted here the right to be heard, the right to a childhood, the right to be educated, the right to be treated fairly, and the right to be healthy. These are just some of the sort of grounded aspects, many of them bearing on the physical, but also you could see equally importantly bearing on the psychological and self-development aspects. So in accordance with the principles of other documents under the UN body, such as the UN Charter and the Universal Declaration of Human Rights, this particular convention refers to certain principles to reinforce these ideas. So, for example, in recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family, the foundation of freedom, justice, and peace in the world rests on these principles. And determined to promote social progress and better standards of life and larger freedom, everyone is entitled to all the rights and freedoms set forth without distinction of any kind, such as race, color, sex, religion, language, political, or other opinion, national or social origin, property, birth, or other status. So it's really sort of setting out the bottom line, which is that the inherent dignity and worth of every individual requires that we respect this set of rights for all persons. Childhood is entitled to special care and assistance. That's also proclaimed in the Universal Declaration of Human Rights, as is the notion that family is the fundamental group of society which is a natural environment for the growth and well-being of all its members, and particularly children. And there should be necessary protection and assistance so that it can fully assume its responsibilities within the community. So borrowing on what Dave said earlier, family need not just be the biological. It's any family context that is offered to the child so that they can grow and develop and achieve their full well-being. Recognizing that the child, for the full and harmonious development of his or her personality, should grow up in a family environment in an atmosphere of happiness, love, and understanding. bearing in mind that the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. In all countries in the world, there are children living in exceptionally difficult conditions, and such children need special consideration. So you really have there a very broad overview of the kinds of considerations that we should always have present in our mind, and particularly when we're dealing with specific groups of children, so children as a category, but also subcategories of children within that group, who for various reasons and conditions outside of their control will need special consideration beyond the special consideration that we already should be extending to children. So all these rights that we see enshrined in the CRC manifest themselves more specifically in terms of particular rights. And there is a distinction I'd like you to think about in terms of how we often speak about children. We usually attribute needs to them. We seldom talk in terms of their rights. So when we talk about food, water, and clothing, we say children need this. They need to play. They need shelter. But if we are more self-conscious of our language and how we characterize these rights, we would be minded to say that these are rights that children have. And so there's a distinction in how we go about then ensuring that these are realized and remain secure regardless of the circumstances in which children find themselves. So all of these rights are at great risk of suspension, whether permanently or temporarily, depending on what the context is in which the child sort of finds him or herself. And so the suspension of any number of these rights, or all of them, certainly can have a permanent negative impact, as we heard earlier, if you consider the absence of some of these rights and what that might mean for the child's development. So this really converges on the core point here, is that every child has this one thing in common, and this is their rights, and all children have these no matter where they are and what their other attributes are. So the CRC is organized within a 3 Ps framework, which I find very useful to help outline how the convention is structured and how it might sort of apply to the work that we're engaged in. People engaged in the environment where children are present are always aware of or are promoting children's rights. And by promoting, it doesn't just mean you're selling the case that children have certain rights to somebody else, but really what it means is you're ensuring that those rights are provided for, right? So you're a part of the provisional structure when we talk about the promotion aspect of the Children's Rights Convention. So you're providing a nurturing developmental context by ensuring that certain rights are ticked off and available and accessible to all children that you come across in the course of your work. So these individuals who are engaged in that context will protect children's developmental context by safeguarding and protecting these rights. And it's important to bear in mind when we move to the next P, which is protection, that we often read that as meaning protecting the child. But it's equally important to remember that you're also protecting their rights, which are part and parcel of protecting the child. So we, again, want to move away from this protective mentality that they only need a top-down, but also try to see from a broader framework how we can engage them in their own protective context more actively because they have agency. And that moves me to the third core principle of the framework, which is participation rights. They have the right to be heard and have their voices included in decision-making about them or about their contexts. They can exercise agency in realms which affect them. And to do this, there must be avenues and structures in place to enable them to do this meaningfully and effectively. So oftentimes, of course, there are routines that we go through and sort of, okay, have I heard from the child? Have I done this or that? But really taking care to ensure that the environment that we create when we work with children is one in which we can realistically anticipate their exercise of agency in a meaningful way. And of course, bearing in mind that that requires patience in the sense that sometimes they may not be ready to contribute in the forum or in the manner that you require of them, and to work with them to help them realize that particular participatory right in a more meaningful and effective way. And to guide sort of the application of this sort of broad 3 Ps framework, there are 4 guiding principles that we should draw on in the context of the CRC. And these should apply in every context. The first is the fundamental principle of non-discrimination against any child on any of the grounds enumerated. And the second, and very core principle, is the best interest of the child, which is enshrined in Article 3 of the Convention. And again, thinking about decision-making and what should lie at the heart of it, and this is something that I'll come back to closer to the end of the presentation, how every outcome that we're pursuing or every sort of opportunity that we have can really provide a framework in which we should always bear in mind at the core that what is the best interest of the child in what I'm trying to do here? What am I tasked to do? And how can I help ensure that this is safeguarded as I do what I'm doing? Third, and almost needless to say, but very, very important, the right to life, survival, and development is fundamental. And so to take a longer-term view of everything that we do, one of the challenges, I think, of being practitioners in the field, wearing the different hats that we do, as whether it's social workers or legal practitioners, is that we are fragmented in our ability to think about the circumstances impacting each child because of our limited lens, whether it's disciplinary or practical in terms of our own experience, which might limit how we think about a situation. But recognizing that, of course, everything that we do is going to have an impact, and there is a knock-on effect on other processes that this family or child may be involved with, and therefore to ensure that these rights are adequately protected, and the idea of the right to life, survival, and their development should be safeguarded regardless of whatever outcomes or solutions we pursue. And of course, as I've mentioned, the right to have their voice and views heard and given due weight in all issues affecting them. So how have we organized this in the work that we're doing? How do we ensure that their views are not just heard, but then also recognized and incorporated? And how do you sort of strike a balance in achieving this participatory right versus any of the other demands of the context or the situation that you're in? So I want to spend the last part of my presentation really focusing on the best interest principle. There is no universal definition or specific definition of the best interest in the Convention itself, but there is a plethora of jurisprudence now that are starting to develop around this concept, and particularly in the European court system and the Australian systems, there are now useful bodies of, you could say, decisions which can help guide us. But this really requires of us to think about how different considerations within a well-defined procedural framework need to be balanced to arrive at an outcome that really safeguards the best interests of the child. So putting the child at the center, but that doesn't necessarily mean that their interests will always come first. The idea is to facilitate an examination of all the interests against a particular framework of considerations in any given context. And that's very general, but as I said, we're going to move into specifics very soon. So what are some of the imperatives that we can think about in the Hong Kong context? You don't need me to remind you, but I'm just going to set the scene a little bit, right? We've got numerous situations of child neglect in Hong Kong. We remember the story of a girl who fell off out of a window of a very high-rise building and died because she was left home alone. Another mom was found guilty of child neglect after feeding her baby diluted formula and leaving his appearance far worse than you might find in other countries where children suffer from malnutrition. And a father in Hong Kong put a 7-year-old child into the trunk of his car as a form of punishment and basically threw his hands up saying, "I really just didn't know what I was supposed to do," and was given a non-custodial sentence. And of course, we don't need reminding of the recent spate of suicides amongst preteens and teenagers in Hong Kong. There's also, of course, the challenges of institutionalized child care, welfare in Hong Kong. We know that the foster care system is at breaking point, and many children are trapped in the residential care system almost permanently, exiting only at 18. And going back again to Dave's presentation, we're now well aware that there are many, many negative consequences of children who are trapped in a system which isn't designed to serve the variety of needs that different types of children that are ending up in these processes have. And so what can we do? How can we better understand what the effects of these solutions that we put forth for children are on them, and in particular on their rights. Is this the only way that we have as a society and as a community to safeguard the best interests of the child? And we all know that in Hong Kong, we do have ample resources, and this is really an opportunity to reconsider how to reallocate our resources and to leverage. There's great wastage of resources in some spheres, and then there's an under-provision in other spheres. How can we harness our collective resources to more effectively reallocate them to address some of the gaps that we see in the system? I want to share with you some of the concluding observations that were made by the Committee on the Rights of the Child. In 2013, in September, I attended the hearing where Hong Kong was being reviewed for its compliance with the CRC as a state party. And the committee's concluding observations, among many other things, really focused on this notion of the participation rights of the child. They appreciate the efforts that have been made in Hong Kong to support organizations representing children. They also note that there are various fora established for children's participation, but they remain concerned that children's views are not sought systematically on all policies affecting them due to a lack of an effective mechanism. There's an absence of procedures for regular review of the placement of children in childcare in Hong Kong. So this was very, very specifically noted by the committee that this process needs to be reviewed. There's also a lack of legislation to look at when the termination of parental rights may be necessary. So in certain contexts where you have domestic abuse, where there is a separation or a divorce in the family, parental rights still loom fairly large. And it's difficult to have those families work together in a context where there may still be a threat either to the partner or, more importantly, to the child concerned. And I don't need to say much about poly-victimization of children because I understand Jessica is going to be telling us a little bit about that as well. There's also insufficient professional support and care for families and children in Hong Kong. And children are deprived of family care entirely when they're placed in residential institutions rather than family-based care, which is really what would be ideally suited for their circumstances. There's also a practice of detaining asylum-seeking children in juvenile detention facilities, which has been criticized by the CRC committee. And here I'd like to pause and again reflect on this idea of non-discrimination and the requirement that in all that we do for all children in Hong Kong, we must always bear in mind there are among those who are more vulnerable than others as well, and they need extra special care. So there are children with disabilities, there are asylum seekers, there are ethnic minorities, all of these groups, or children who exhibit different sexual orientation or gender identity crises, they all need to be taken care of and looked after specifically with great attention to their needs. There's also a paucity of mental health services for our children. The committee recommended that we put more emphasis on the protection of children's rights, particularly in government policies and legislation, and to ensure that there is adequate consultative mechanisms in place. And also, really, we've been asked to incorporate the best interest principle as a standard of best practice by having a checklist, perhaps in policymaking as a start, to ensure that we do undertake all those considerations that are relevant in formulating law and policy. So, for example, we might encourage different stakeholder groups to come up with systematic indicators for, or a framework through which to guide our work, or we could implement a child impact assessment system that compares the before and after effects of a policy. So there's really a need for monitoring and assessment. So this requires a multidisciplinary collaborative lens to offer a comprehensive overview of the considerations that might come into play and to enable us to evaluate the broad-scale impact and how different strategies can be applied in order to ensure that there is attention to detail in realizing the best outcomes that are in the best interest of the children. So the UN has certain guidelines as factors to consider under the best interest principle, and obviously, Dave touched on a lot of these, but broadly they include physical, emotional, educational needs, as well as attention to the likely effect of a change in circumstance on the child concerned, the risk of harm or suffering, the parent's capacity, the age, sex, background of the child concerned, their own voice most importantly, and then to look at the range of powers or remedies that might be available if you're in a court context or outside of that. What are the possibilities? What is the realm of possibilities? And to realize that these lie on a spectrum, and sometimes we have to move the boundaries a little bit in order to achieve what is best for the child. So I'd like to end on this quote that I really like by Anne Frank. There are distinct best practices that can be developed in our own individual fields, and we can draw on the 3 Ps framework as well as the guiding principles that I described above. And really what I want to say today is for all of us to sort of think about how we don't need to wait and we can just get started, and that's what I hope that we're going to be doing throughout the rest of the 2 days here. So in this next segment, we're going to have 2 practitioners from the field who've worked with children, and they're going to share with us the specific best practices and approaches that can be integrated into practice to realize more child-centered outcomes that are in the best interest of the child. And through our conversation, they're going to share with you how do you conceptualize different situations from a best practices and best interest perspective to reach solutions that are consistent with the CRC framework. I'm just going to briefly introduce to you both our speakers, and then I'm going to come and join them in a moment. So Jessica Warner is she holds a BA in both psychology and sociology, as well as an MSW in social welfare and an MA in criminal justice. She's recently completed a graduate study abroad in international social welfare and a fellowship in human rights, as well as has a leadership certificate in both children's policy and nonprofit leadership. Until recently, she was an assistant director of the New York Foundlings Fontana Center for Child Protection, where she managed the center's policy advocacy, public awareness, and professional development initiatives. She's soon going to begin working for the Administration of Children's Services in New York, developing a new curriculum and leading workshops to train social workers and other frontline staff on rights-based best practices for child protection. She also serves as an adjunct faculty at the City University of New York Hunter's Silberman School of Social Work, where she teaches social welfare policy and child welfare policy, and John Jay School of Criminal Justice, where she teaches an interdisciplinary course on youth justice. She's previously worked for many years for the Legal Aid Society's Juvenile Rights Practice and Special Litigation and Law Reform Unit, providing direct case-based advocacy in family court, as well as a cause-based advocacy by systemic law and policy reform of child welfare and juvenile justice systems. Prior to joining the Legal Aid Society, Jessica worked in numerous out-of-home care and justice institutions for youth and adults, placed in foster care and correctional facilities. She's also had experience teaching children's and youth rights to the New York City high school students, and social change and human rights to women detained on Rikers Island. She's equally passionate about reform of child welfare, youth justice, and criminal justice systems, and specializes in systemic issues impacting children who are dually involved with both the child welfare and juvenile or criminal justice system. Needless to say, Jessica's profile really harnesses both the legal and the social work dimensions, and her variety of experiences and positions in the past, as well as her teaching positions, really place her uniquely to be able to offer deep insights into the conversation that I hope to move into. I'd also like to now introduce to you Pia Mukit. Pia has been working in the field of human rights, child rights, human trafficking, and refugee rights for the past 16 years as a legal aid lawyer and policy expert. She's worked for a variety of NGOs, including Freedom from Torture, Redress, and Refugee and Migrant Justice in the UK, the Capital Post-Conviction Project of Louisiana in the USA, and Aino Salish Kendra in Bangladesh. She's also served on the board and worked for the Citizenship Foundation and Grampian Racial Equality Council. Pia is a qualified barrister, having trained at Doughty Street Garden Court Chambers and the Faculty of Advocates in the UK. She holds an undergraduate degree in law from the University of Aberdeen and a master's in human rights from the University of London and a master's in child studies from King's College London. She's led on change management projects for several NGOs, and she's been heavily involved in training and capacity building, research, strategic litigation cases, and law and policy reform throughout her career. We work with her closely where she is now at the Hong Kong Justice Center, where she was head of policy and advocacy And before then, she was head of policy and advocacy at UNICEF in the United Kingdom. So also from Pia's profile, you can see she's also more than qualified to speak to us on a range of the topics that we're going to be discussing on our panel shortly. So I'm going to join you both over there. So I'd like to start off with Jessica by asking you. So we've got the principles, we've got the framework, but really, how do we incorporate these broad principles into daily practice? And how do you use these principles to guide your work? Because there's such a range of cases that you come across. And how do you keep that work or your planning sort of child focus?
Thank you so much, Pooja, for the great introduction, and thank you for having me on the panel. I also just want to say quickly thank you to everyone here at Hong Kong University and Mother's Choice for hosting this incredible conference, which I'm really excited to be a part of, not just to share my own experience, but also to learn from all of you, those who are presenting and those who are here in the audience today. Special thanks to Lindsay Ernst for finding me and bringing me into the program. And I just want to say that to the folks at Mother's Choice, I was really inspired by the work that you're doing. When I came to your facility yesterday, it would be easy to leave feeling sad, I think, but predominantly I left feeling inspired, so thank you for that. So first, I just want to start out by mentioning that for those who do children's rights work, you may know that the United States is the one remaining nation that has not ratified the Convention on the Rights of the Child. And I'm coming from the United States, so it might seem a bit odd that I'm doing this presentation on best practices. It comes to my great dismay that the United States has not yet ratified the Convention on the Rights of the Child. So I want to acknowledge that, and I just want to say that despite that being the case, I consider the Convention on the Rights of the Child to be the most important document that I conduct my work based on, and I think that the fact that the international community has all, with the exception of my nation, ratified this important document. I think it was also the most quickly ratified document by everyone except the U.S. I know I keep saying that because I'm very upset about it. So I think the fact that the international community does recognize this document is really one of the most important factors in my own use of it. Clearly, it's important to everyone else, and it is important to many of us in the United States. And I sort of insist to my own students and practitioners that I do my professional training work with that, despite the U.S. not having signed, or what we have signed, not having ratified, the entire international community is behind it and upholds it as international law, and that in itself is really important. So, having said all of that, I'm going to jump into some of the best practices. Oh, in that direction. There we go. All right. So, starting with differentiating between children's rights and as opposed to children's needs. Pooja actually gave a great summary of what the difference is and why it's important that we highlight children's rights as opposed to simply their needs. So I'm not going to be redundant with that, but I am going to pull up this quick chart, and you can see from the link at the bottom, if you can go to it now, you can see a better chart that has more detail, or you can go to it later. The link, just in case anyone can't see it, is www.replace-campaign.org. You don't have to go to it now because I'm not really going to reference it, but so for anyone who wants to, you can check it out later. But this is a sort of quick summary of what I think are some of the key important points between differentiating between children's rights and children's needs. So starting with assessment, for those who are social workers, this is something that we do all the time. When we do our assessments, a needs-based approach would say that that we focus on the assessed needs of the child, but that would only be relevant to children who have a specific identified need or set of needs, right? So, and then the rights-based approach talks about everything being based on an established universal rights and applicable to all children everywhere. So by definition, universal rights really means that it applies to everyone, right? Just by virtue of being a human being, or in this case, being a child who is a human being. So that's the most basic version. But beyond that, if you look through at the second row, the differentiation between in a needs-based approach that there is no obligation to meet needs, right? So if we have limited resources, we don't have all of the resources to meet all of the needs of the children that we are working with, then so be it, sort of. That's the end of it. We don't have the resources, that's that. Whereas the rights-based approach would say that states and international entities have an obligation to meet rights. So perhaps we don't have the resources, we need to come up with the resources, we need to create a situation where we can meet those obligations. And then it also, the rights-based approach in contrary to the needs-based approach, holds those in positions of power at all levels accountable, whereas the needs-based approach would say that those in positions of power are asked to be helpful, and if they cannot be helpful, then again, so be it. So focusing on making sure that all of us, actually, not just those who are states or international entities, but anyone in a position of power, being sure that we hold ourselves accountable. So that includes all of us in this room who work with children. So I'm gonna move to the next. Oh, I'm sorry, I'm gonna go back. Differentiating a little bit between universal rights and cultural relativism. These are two key concepts for those of us who do children's rights work. So again, universal rights is by definition applicable to everyone, and there are no exceptions to that. Whereas the concept of cultural relativism is really about cultures being able to define their own values and ethics. For some reason in the field, a lot of folks tend to lean towards one or the other and sort of treat them as if they're dichotomous. My best practice approach, or what I think is best practice approach at least, is that we uphold both principles and that we recognize that there is actually an important tension between the two of them and that they sort of serve as checks and balances to one another. Both concepts have value, and so when we're thinking about universal rights, it's important to recognize that there is some value in cultural relativism. And when we're thinking about cultural relativism, it's important to recognize that there is value in universal rights. So what I essentially say is that that rights, children's rights, human rights, are relatively universal. It sounds a bit paradoxical, but essentially it means that we do uphold universal rights, universal human rights, and universal children's rights, but with some limitations or with some recognized stops to our approach or to our thinking. So child welfare, differentiating here between child welfare and child protection. The Convention on the Rights of the Child in Article 19 specifically speaks to child protection, but the entire Convention on the Rights of the Child is essentially about child welfare. So child protection is one key component of child welfare, but when we focus on the protection of children from harms, and we focus exclusively on the protection of children from harms, we're missing all of the other really important pieces. So what I say to my students and to anyone who I'm doing professional trainings with is that it's not enough to say that we are child protection practitioners, or it's not enough to say that we work in child protection. Also, we work in child welfare, and even more specifically, we do children's rights work. Okay, so well-being. Here, this is really about going beyond safety and permanency. Of course, focusing on safety and permanency are incredibly important to the work that we're doing, but we get very stuck in focusing on just safety and permanency, and we forget to go beyond that and to focus on the broader well-being of the child. So the Convention on the Rights of the Child, for example, in Article 24 talks about all children having the right to quality health care. And in Article 28, it talks about all children having the right to education. And those are just a couple of examples from the Convention on the Rights of the Child that go beyond both safety and permanency to reflect the overall well-being of the child. And it's also sort of just about normalizing experiences for children and adolescents. Those who are child welfare involved often don't have access to sort of normal, quote unquote, child and adolescent development experiences. And so it has to do also with making sure that we are able to provide those normal experiences for children. And then just to sort of piggyback on what Mr. Anderson said this morning about protective factors, it's also about highlighting protective and promotive factors. The next one is about interdisciplinary practice, which I believe that Pia is going to take from here. Yes?
Yeah, so thank you so much, Jessica. Pia, I'd like to ask you the same question. How do you integrate sort of these best practices into the work that you do? Or what are sort of your core best practices that you bring to the work that you do? And then we'll get to the interdisciplinary question.
Okay. Well, I want to thank Mother's Choice and HKU for the opportunity to speak this morning to you. Just as a caveat, I have practiced for many years in the UK in this area, but I'm not a practitioner in Hong Kong, so I'm really looking forward to learning from all of you today about how to work, the frameworks which are in Hong Kong, and also how we can improve children's rights in Hong Kong. So that's really coming to you with my perspective of how we did things in the UK. In particular, the focus was, for me certainly, was on refugee children and asylum-seeking children. So in Hong Kong, we have 500 to 600 asylum-seeking children. In the UK, we had thousands. And it was, Jessica mentioned that the US hasn't ratified the convention. However, the UK, when they did ratify the convention, they actually put a reservation in, which existed for a decade, which excluded the CRC from applying to asylum-seeking refugee children. So all of the benefits and all of the rights that were enshrined in the CRC, in fact, if you were a migrant child, you couldn't actually access or rely. So it was something which children's rights organisations in the UK all had to work very hard to convince government to withdraw from the reservation. So even though the UK has a very long history of child protection and working in this space, when it comes to refugee and asylum-seeking children and trafficked children, we're actually quite new in that really it's been since 2008 that actually we've been taking some of these areas of best practice into looking into how we work with these particular children. And I think the difficulty was that there was lots of guidance and lots of law and policy for other children, and there was really nothing for asylum-seeking and refugee children. And I think the very first kind of right that we had to look at was, what do we mean by best interest of the child? And that was actually something which really everyone had to grapple with, because we are looking at children's rights, we're looking at putting children at the centre, we're looking at working with children holistically, but at the same time we had the competing factor, which was immigration control. And so those two things were really challenging for professionals across the board. So not just social workers, but lawyers, by psychologists, by clinicians, anyone working with this very vulnerable group of children had this kind of direct kind of conflict of, we know that immigration control is there, and we know that these children are in a separate system, so they're not necessarily in the family law system, but at the same time, how are we going to ensure that these children actually benefit from the convention? So that was really a big challenge. And so how we started with best interests was really, guidance was produced. The government did look to other departments which had lots of experience with this, particularly the Department of Education. But ultimately, unfortunately, it did have to go to the courts, and it was in fact the Supreme Court that was able to give that guidance to everybody about what best interest of the child actually means in practice. So it's kind of just to really say that until we think of all children as the same and not separate them into our children and outsider children, or these children are not the same because they don't have the same immigration status, then really, we're not really thinking holistically, and we're not really thinking about what the spirit of the convention is there for, which is not to discriminate against children in any way.
Thanks, Pia. I'm going to jump back to Jessica for a second to lead us through the last 2 points on your slide before we move to interdisciplinary practice.
Okay, so a couple more points having to do with using a child-centered practice. So actually, Pooja spoke about this in her introduction as well, so I won't be too redundant here. But essentially, it's differentiating best interests from what I refer to, and many of us in the U.S. refer to as expressed wishes or stated wishes. The Convention on the Rights of the Child in Article 3 talks about best interests, as Pooja mentioned, but in Article 12 talks about the right, a child's right to have their views given due weight in accordance with age and maturity. And we often forget, for some reason, about Article number 12, and we focus on Article 3 exclusively, emphasizing best interests as opposed to the child's right to have their views given due weight. So what I want to say about that is that essentially best interest is the most value-laden term I've ever come across in the social work field. It essentially is a concept that changes over time and is interpreted differently by different people, and it's really hard to say what is in the best interest of a child. And sometimes we tend to focus on what we think is in the best interest of a child from our own perspective. But when we do best interest work, and we do have to do that sometimes, or what we have to do in the U.S., we refer to, or at least at the Legal Aid Society where I used to work, we refer to substituting judgment, which is similar to the concept of best interests. But really that's about doing what is best for the child in their own context, so in their own culture and in their own environment, as opposed to what we think will be best for us in our culture and in our environment. So that's differentiating between those two. And so keeping a child-centered practice really is about remembering Article 12 and making sure that we uphold that article. And the last point here is about specialization. So at the Legal Aid Society where I used to work, we had what we call specialization, in that everyone focused. So first, I would say it was about all of us having a specialization in working with children, and children who were child welfare involved, or in some cases juvenile justice involved. So that's about making sure that our lawyers and social workers and paralegals and everyone in different disciplines not just focuses on the law in general or in human rights, but has a specialization in working with children. And then to go beyond that, many of us would have a specialization in focusing on specific populations of children who are marginalized or vulnerable. So whether that was children, refugee children, or whether that was children who were homeless, or children who had histories of sexual exploitation, or whatever it might be. And that's it for that.
Thank you, Jessica. So, both of you mentioned this need for interdisciplinary practice, or this lens that you bring to the work. How is it possible to devise solutions which incorporate multiple lenses? Obviously, everybody comes from different sort of backgrounds and training, and in particular, when we're tasked with something, we have our own sort of vision for what needs to be achieved in a given circumstance. So it can be very challenging, but also very limiting because it's so fragmented. And then there's the risk, where there's compromises because people feel, well, had we known this piece of information, then we might have moved towards something different. So what is the role of, and how important would you say is multidisciplinary collaboration in overcoming the kind of challenges that children face, and in particular in achieving the best interest principle?
So if I can answer this actually by giving a practical example of how we grappled with this whole issue. So, I'm a trained lawyer, and as a lawyer, I was, very confident in my knowledge of how to use the law and apply the law, but I'm not a trained social worker. I'm not a psychologist, and I hadn't actually worked with children in the sense of I hadn't worked in education, or I hadn't worked during my training necessarily with children. And I think certainly in the asylum field, the majority of lawyers came from the same background. You know, we knew what we were doing when it came to the law. But when it came to children, it was, and it's actually something, Jessica, what you were saying about specialization. I was working for an NGO that had been around for 25 years, and it was the largest NGO that represented refugees in the UK. And we didn't actually have a specialization in children. What was startling to me was the first case I remember dropping on my desk, and I'm reading it, and throughout the decision, I thought, the judge was talking about an adult, and it was only at the end I realized that it was talking about a child, because the representative had actually referred to the child as Mr. all the way through the hearing, and so the judge everyone had treated this child as an adult, and there'd been no special procedures in court because this was a child. And for me, it was really one of those moments where I thought, hang on, we represent hundreds of children. Are we doing this systematically? And then we realized, actually, by doing a needs sort of internal examination as an organization, we thought, we're not, because as lawyers, we've been so focused on just ensuring that we're preparing the cases and we're getting the best evidence, but actually we've forgotten it is children that we are representing. And it's actually kind of accepting that this isn't our area and isn't our field, and it was reaching out to other professionals and having, I guess, that humility to say, look, we don't have the experience, but you as social workers have the experience, or you as children's organizations that have been working in the advocacy field, or you're doing frontline work. And it sort of grew, a movement began. This was around kind of 2007. So this is before the reservation had even been removed, that actually we need to get better at this. We need to be working across disciplines, and because in family law, there had been so much work done with multidisciplinary work, but within asylum law, it'd been completely isolated. And so this idea of, it was easier in the UK because we have law centres, for example. So if you're a social worker and you want to get some advice, you know, you're working with a child and you want to know, well, you know, what is the legal position? You can go to law centres and you can get that legal advice. Or often social services have their own legal departments. So you have access to that already. But it really still wasn't enough, because there were organisations that were working in abuse, for example, who had been doing this for decades and had a lot of expertise that could then lend to this particular sector. And I think that was really kind of how, when we're talking about multidisciplinary work, it's really accepting that strengths and weaknesses of different sectors, but actually working together, you are going to actually pool all your best strengths. We were fortunate in that the UK government at the time was quite open about their lack of expertise in this area, and they'd set up an office called Office of the Children's Champion, which did have a social worker, and it had a policy advisor and had several other civil servants, but it wasn't their area either. They didn't come from the Department for Education, who really held the kind of remit on this work. And so they came to civil society and they said, work with us. We want to work together to get good policy that's going to be implemented on the ground. And that has, and that didn't start sort of within year one. Suddenly we've got, beautiful policy, or we've got beautiful practices. It's been a very long process. But one of the kind of key areas was age assessment. And age assessment is an issue where it does involve social work, it does involve lawyers, and it does involve judges and decision makers. And there had been so much litigation around challenging social workers' assessments around how to assess a child's age. And then the medical profession were involved as well, because at one point it was, we should be x-raying children, or we should be taking their dental x-rays or bone x-rays. And then there was the ethical considerations that came into that. And so suddenly all these different actors had to come together, because there was the volume of cases that were going through the courts, challenging age assessment after age assessment. And then a concerted effort was made, was actually, rather than just continuing to litigate and continuing to rely on judges who themselves are not experts, why don't we pull together as organisations and actually draft some guidance to help each other? And the kind of final result was in the end of 2015, an age assessment document was actually produced, which was practical guidance, which was written by social workers, was written by the lawyers were involved, the Red Cross was involved, the NSPCC, UNHCR, like multiple organisations, the Refugee Council, children's legal centres, and it was really kind of to show that we all come with a different strength, and we produced this guidance, and it's not binding by any means, but it has now given, empowered actually the community to think about working across the disciplines. So if I'm working a child in education who may have there may be an issue around immigration status, or there may be an issue around trauma, or there may be an issue around access to welfare, then rather than me trying to solve this on my own, and it's more than just a multidisciplinary case meeting, or in the UK we use the common assessment framework, it's more than just calling a meeting. It's actually reaching out and identifying where those gaps are and trying to address them together as a sector.
Thanks so much, Pia. So I think Pia's nicely sort of laid out the broad setting in which we can all collaborate together when we're talking about policy level gaps that we see and how, what we can each bring to the table. I'm going to now move to Jessica to ask you specifically, how do you systematize multidisciplinary collaboration on a case-to-case basis? How do you organize or structure your relationships with different sectors so that you can draw on that resource constantly?
Systematize. Okay. It might help if I use the case example at this point. Would that be useful?
Sure.
Okay. So I'm going to actually move ahead in the slides then.
So perhaps then you might want to give the background that you have prepared, right? Because we were saying that there is a range of types of contexts in which children may find themselves where different professionals are called in. And so best practice and best interests require something different in each case. And then Jessica's going to share an example of a case and then try to talk you through what she has done to give you an idea. Yeah.
Okay. Okay, so first I'll give just a little bit of background on some of the young people that I have worked with, and then I'll move into the case example to give a more concrete example. So I was asked to speak about specific challenging cases of children who are stuck in institutional care. And the list here, I'll just I won't go through each one for the sake of time, but I'll just read it aloud for anyone who doesn't read English. Adolescents, children who run away from their placements, children who are hard to place, which sometimes has to do, or often I should say, has to do with severe, or what we think of at least as severe, behavioral or emotional challenges. Children who experience frequent placement changes, that often has to do with poor placement options. Sometimes it has to do with attachment difficulties, and probably more often than not, it's a combination of the two. We tend to think of it as either or, but often it's both. And then children who are involved with both child welfare and youth justice systems. And then a whole slew of different sort of special populations of children who are vulnerable or marginalized. Such as infants and toddlers. We usually think of ages 0 to 3, although some say 0 to 5. Adolescents, girls, ethnic minorities in the U.S., that's usually Black, Latino, and Native youth, Native American youth. Children who identify as LGBTQI, so in the U.S. that's lesbian, gay, bisexual, transgender, genderqueer, and intersex, or GNC, which stands for gender nonconforming. Unaccompanied immigrant children and refugee children, and then a few others. Children with chronic medical illnesses, children with disabilities, children who are being sexually exploited, children who are poly victims. I have a quick slide on that so that I can highlight a little bit more about what that means for those who are not familiar with the term. In the U.S., we refer to poly victims as young people who There's a list. Young people who have experienced victimization from a variety of different sources or in a variety of different ways. So often in the child welfare, we're very focused on children who have experienced physical abuse, sexual abuse, or neglect. But there are a lot of other forms of trauma and losses that children and adolescents experience. And so some of these other ones have to do, for example, with witnessing different forms of violence, being the victim of a crime, system-induced trauma, which we often forget about, even though we work in the system ourselves every day. We forget about the trauma of being removed from your family, or the traumas that come up when you're in institutional care, of having all of your freedoms restricted. Sometimes there's abuse within the system, disrupted caregiving, and there's victims of war, terrorism, natural disaster. So that's what I mean by polyvictimization. It's really about recognizing that the children that we work with, the adolescents that we work with, are often victims of many different forms of abuse, neglect, loss, crime, violence, etc. Thank you. Okay. And children coping with mental health challenges, including substance abuse, children with problematic behavior, or children who have had police contact and contact with justice systems, and then children of incarcerated parents. Perhaps there's others that I have not thought of, but that's the list that I came up with. Do you want me to move into the case example? Okay, so I came up with a specific case example that I'm going to share the details of. Please forgive me, I'm going to refer to my notes because I was asked to pick out a specific example of a very complex case. Because I picked sort of one of the most complex cases that I could come up with, there are many different factors involved that I didn't want to forget any of the key pieces of. So this is a child that I worked with, an adolescent that I worked with. I'm going to tell you her first name, which is Gwendolyn. I usually don't use a first name for confidentiality reasons, but because we're so far away from home and because this is a case that was quite a few years ago, I don't think there's any problem for me to do that. And I think it's important for you to hear her name when I speak, because it, I think, will help you think about her as a full human being. So Gwendolyn was 15 years old when I met her. She was an African-American girl, which I'm going to remember to come back to, but I want to give you some of the background right now, because being an African-American girl is important. She was from a family living in poverty, very low-income neighborhood that she lived in, actually one of the poorest congressional districts in the U.S. Her mother had filed what is called a PINS case in New York City. It stands for Person in Need of Supervision. And essentially what that means is that the mother is able to come to court and file a legal case against their child for what we consider a status offense, which in America means that it's not a crime because you're a child, but essentially it's an act that would be that is sort of treated like it's a crime, even though if you were an adult, it wouldn't be. So I'll give you a couple of examples. Running away from home is considered a status offense. Not going to school, being disobedient to your parents, those are status offenses. So her mother brought a PINS, Person in Need of Supervision, case against her child. And that outlet allowed her mother to place her into Child Protective Services. So she was placed into Child Protective Services. Some of the additional background is that her mother had been physically abusive with her as well. So even though this is a case filed against Gwendolyn, her mother perhaps might have had a case against her if it had been known to the system. She had witnessed her mother being abusive towards her father and towards other men. So often we think of it, domestic violence, as violence from men to women. But in this case, the mother was abusive not only to her, but to men in her life. Gwendolyn was being sexually exploited by, she had a pimp. She was being sexually exploited by her pimp and by the many Johns that paid to have sex with her. Gwendolyn was a poly victim, so I talked a little bit about what that was. So essentially, the fact that she was being physically abused, she had a history of witnessing violence in the home, domestic violence, and the fact that she was being sexually exploited, in addition to some of the losses she experienced that were system-induced made her someone we would consider to be a poly victim. So Gwendolyn came to my attention on a delinquency case. So I know I said it was persons in need of supervision, but I wasn't involved at that point. So the lawyer was involved at that point. She was doing a great job on the case. She perhaps could have benefited from a social worker earlier on, but unfortunately, we didn't have the resources for a social worker to be on every single case. At the Legal Aid Society, we had enough resources for social workers to be involved with about 15% of our cases. And so I got pulled in once Gwendolyn had a criminal matter, a delinquency matter filed against her, and it was for her damaging some property in the group home that she was living in. And so that's something that we often see in the US, is that children who are child welfare involved, when they're in institutional care, any sort of behavioral problem that they have, which often is trauma-induced or is a way of acting out some of the traumas that they've experienced, you'll see that the group homes or institutional forms of care, residential treatment centers and whatnot, will file a case against the young person. So in addition to all of that, there were many other complexities with Gwendolyn. She was in special education for having a learning disability. Her IQ testing reflected she was possibly borderline for mild mental retardation. She had a history of many different mental health diagnoses and psychotropic medication trials all across the board. You name the diagnosis, she had been diagnosed with it. She displayed sexualized behavior in both the group home and school. As you can imagine, that was probably a reflection of her having been sexually exploited and sort of acting out some of that. She used alcohol and marijuana. She often insisted that she was pregnant all the time, and there would be testing done and it would turn out that she was not pregnant. And the staff would insist that she was that she was a liar, essentially. She was referred to as a child who lied a lot. She also showed some aggression towards peers and even staff at times. So I want to talk a little bit about what happened once I got involved in the case. CPS was trying to have her placed in a locked facility, which we know from the Convention on the Rights of the Child, Article 37, is supposed to be used as a last resort, and in this case it was something that they were jumping to as a first resort.
Sorry, CPS, if you could just elaborate for everyone.
Yes, I'm sorry, Child Protective Services. I think I said it earlier, but I'll keep making sure that I spell out the acronym. So Child Protective Services. So the first step really was this multidisciplinary approach that Pia just spoke about at some length, of getting a social worker involved in the case. So as I said before, it was just the attorney before, but she wanted to pull in someone who specialized in working with this population and had the social work background, and so that person was me, having been being someone who specializes in children who are involved with both the child welfare and juvenile justice system. So that involved, first and foremost, building a rapport and a foundation of trust with Gwendolyn, really listening to her and her expressed wishes, not just thinking about her best interests, clearly conveying to her that we were going to represent her rights, not just what we perceived as her needs, and making sure that she understood what her rights were and that that could be used as a tool of empowerment for her. Taking the time to sort of emphasize her strengths and to be careful with the language that we use so that we didn't focus just on deficits or problems that she was experiencing. And then conveying to the judge both some of the adverse childhood experiences that she had, but also what we refer to in the US now as adverse community environments. So the fact that she was an African American youth who was experiencing discrimination, as many African American youth in the child welfare and juvenile justice systems in America do experience, and a child coming from a family living in poverty. And we used an approach with Gwendolyn to sort of pull out what some of the other resources she might have were, so some of the other family members or close family friends that she might be able to connect with. And then we explored some of the issues that she was having in more depth. So as I mentioned before, she noted that she had been pregnant before. She was saying that she was pregnant many times and was being referred to as a liar, literally being called a liar. And so we delved into that a little more deeply to find out what was going on with Gwendolyn. And she had an abortion before, and as it turns out, she was experiencing a lot of grief from having been pregnant and sort of having been pressured into having an abortion, and so that's part of why that was coming up for her. So that's just one example of sort of what we delved into in a little bit more depth. So to tell you the outcome of Gwendolyn's case, ultimately Gwendolyn was placed with her grandmother, fortunately, and her grandmother's husband into what we call kinship foster care. Unfortunately, she was placed on probation through the juvenile justice system, but for us it was a win in that she wasn't incarcerated. She was placed into trauma-based treatment, which I highlight because often we put the children into general counseling services with folks who don't have a background in trauma. So that's, again, about the specialization. And then having some family counseling because her grandmother was having a hard time making a connection between her trauma symptoms and some of the behavior she was having. And then we ultimately sort of had a backup plan if we needed it of having her be in some specialized services for girls who were being sexually exploited. But fortunately, we didn't have to move forward with that counseling because she did well in her grandmother's home, got out of institutional care, and did okay on probation and in a new school. And that's it.
Thank you so much, Jessica. I think that's really a very, very valuable example, and thank you for sharing so candidly about it. You highlighted not only the complexity of the range of aspects pertaining to Gwendolyn's case that needed addressing, and I think you also sort of helped signal how important it is not only to ensure that you confer meaningfully with the client, but also that we watch our language. So you talked about using empowering language and trying to reframe some of the narrative that was being written around her as an individual. So I really appreciate your sharing that. And obviously that led to particular outcomes which were clearly very important for Gwendolyn in terms of the kinship foster care outcome that you mentioned, and then also the response of the criminal justice system, which wasn't as harsh for her as it might have been. So all of these are really direct consequences of bearing in mind and having undertaken a proper full-scale assessment of all that's going on, and then mapping together how the different factors might be impacting or exacerbating some aspect of her situation, and then seeing her as a partner in sort of working out what might be best for her, because she has a right to the best outcome in this particular instance. Pia, I'm going to ask you as well to please share one of the cases that you had, and what was your experience in terms of a multidisciplinary collaboration, please?
So a case I'm going to share is not a case where I was the lawyer, but where I was working, this is when I was in Freedom from Torture, so I was the legal advisor in the organization, but the client, in fact, had their own lawyer who was representing them in their asylum claim. But she was coming to Freedom from Torture for rehabilitation because she had come from the DRC, Democratic Republic of Congo. She suffered from extreme sexual abuse, but then it led into gang rape and then other forms of torture while in detention. And she'd actually arrived in the UK while she was a child. So she was pregnant as a result of being raped in detention, and she'd arrived in the UK, and at that time, because she was on the cusp of being 18, social services hadn't in fact taken her into care, so she was living in residential care that was being provided by the immigration service. So it was a separate system. And the issue was about her unborn child, and what was very complicated about this case was she herself, because of the circumstances of how she was pregnant and because she was articulating, distress of being pregnant because of rape, it was very challenging because she was working with clinical psychologists to address her own torture, but also she was working with our children, young people, and family team who were helping her through her pregnancy. But in addition, she had her asylum lawyer who was helping her through the system. And to add on to the complication, she had on another whole layer, which was the social services of the area that she was living. They felt that her unborn child would be at risk if the child wasn't taken into care immediately when the child was born, because what they identified was this was a torture survivor who was mentally unwell and unstable and would be a risk to the child. So there was all these multiple layers to this case. And what was, I was called in at a point where our children and young people family team, and this was through an NGO, were trying to work with social services, and there was just a complete breakdown between the social workers in the NGO and the social workers in social services, and they could not communicate with each other. And then on top of that was the asylum lawyer who was saying, well, my client is this young woman, the unborn child hasn't even acquired any rights yet as an unborn child. So it was very complicated. And what really struck me was the kind of lack of participation, actually, of our client in this whole process, where there was 4 different parties all wrangling over the kind of consequences. And no one had actually thought, what does mum want? What does this young person need? But more importantly, what does she feel is going to be best for her, and what's in her best interest and what's in her child's best interest? Because she was saying, I am upset and distressed because of being pregnant because I'm raped, but that didn't necessarily translate as I don't want this child either. And I think that was really what was startling, was that this had gone on for months and that no one had actually really spoken to her and asked for her wishes. And everyone had sort of piled in with this assumption that, but you're under 18, so as you're under 18, we know best for you, taking on this very paternalistic kind of role of like, we can make those decisions that's in your best interests, completely ignoring the kind of key thing of, well, what's her participation in the decision-making process. And ultimately through bringing actually, because I was almost a neutral party in a sense, because ultimately, because I was a practicing lawyer, I said my duty is not to the organisation, actually, it's to, I have professional duties, and so I have to be neutral, I have to look at this and assess this case neutrally, and then I have to give my advice on what I think is the way forward. And I advise that I think everyone needs to just sit down in the same room and actually start speaking to one another without the threat of legal action, left, right, and centre, and mum being taken into care, and the children being taken, the baby being taken into care. And ultimately what was resolved, and it was just, as I said, miscommunication between all the different parties who just did not know how to work together because they hadn't worked together. And really when we were able to bring people in and sit them down, and through the kind of, what I was able to explain was, do we all want to be protracted in very long family court proceedings? Let's try and avoid this by working out a care plan. And what was ultimately decided was that mum would in fact be taken into foster care. But then also when the baby was born, mum and baby would be supported in foster care by finding an environment where mum could actually bond and attach with her child, rather than just making this assumption that mum's been tortured, mum's a refugee, mum has, therefore, this child is unsafe. And that was kind of a practical example, really, of how to navigate when you've got different parties and different needs coming in.
Thanks so much, Pia. Again, you've highlighted and touched on some of the aspects that were coming through with Gwendolyn's case about the complexity and then the narrative and then the assumptions that we rely on in order to decide, well, what's best in this particular case. One final question that I'm going to end with for both of you, really. So for example, in any given situation, you might have a client. There are different entry points. You might go to the lawyer first because of a certain trigger, or you might end up having a social worker work with you. So you often get conflicting or I guess mismatched responses and needs at a given moment. So you might have a lawyer who says, well, she wants to talk to me about her life story, but I don't have 2 hours because I'm not a therapist and I don't need all that information. It's not relevant to what I need to do for her. On the other hand, you might have a social worker who may not be well experienced in working with particular types of population groups, and all they have to rely on may be a set of stereotypes because they haven't delved into it. They're not an expert, but that would affect negatively the kind of profile that they craft of this individual, And that profile is going to affect or feed into the work that everybody does, in the system with this particular child. So at the same time, of course, not everybody can be well-versed in everything. And so it can be very overwhelming to expect of anybody to know everything and then know how to be. So it's extremely challenging. How do you overcome this challenge and engage everyone productively by leveraging on their expertise? And it's obviously sounding very labor intensive, right? Because both of you alluded to how it's important to, sit around the table with everybody concerned and then say, this case or this situation could end up here and it's going to cost this much and, not be a good outcome for anybody. And how can we save it from that? Is it a practical and realistic expectation to have that you're always going to be able to get to that meeting and have everybody who needs to be there? Or, is there it goes back to the question I asked Jessica, is there a way to systematize collaboration so that we can make the process productive?
If I can start, you're absolutely right. You can't always get everybody around the table. And my early career was actually in I used to represent children in the criminal justice system, and that was one area where you could not get everybody to the table. And it was for many different reasons, mostly resource-driven actually, where it was just very, there wasn't the budgets and people didn't have the time and social workers weren't going to sit and talk to criminal defense lawyers, and it was kind of racked with many systemic problems. And I think that's where, and I had actually kind of was quite negative that this whole approach, multidisciplinary approach, doesn't really work because you need to have resources and people need to have be empowered to do the work. And I think where I saw the game changer really was actually working in the asylum sector, where it actually began with conferences like this one that we have right now, that's being held for the past 2 days, because it started off with conversations. Because how do you begin to actually set up a framework? You have to begin by bringing everyone that has an interest in that issue to the same place. And at the very beginning, it was like there were multiple conferences and meetings and groups were being formed. And it was kind of a gradual kind of evolution, really, because then it was saying, well, this is going to be helpful. I can't wait around for the Department of Education, or I can't wait around for the Home Office, or I can't wait around, for this department, government department, to draft policy. Why don't we as professionals start to draft our own guidance that we can assist with each other, but also we can set up frameworks as best practice? And it seems like kind of really obvious, but it's something which, as I said, was very new. It's only been the last decade in the UK that's really, really within, certainly within the asylum sector, that's been a kind of a practice now. But it began with, understanding that it's not always going to be possible to have everybody at the table, but I need guidance. If I'm a social worker in an area where there are no other NGOs, for example, or there's no other professionals that I can reach out in because I'm working in an isolated area, at least I can start with looking at some practical guidance that's been written by practitioners, and I can actually know who I'm going to call on. And so what followed on from the conferences was actually a huge training and capacity building piece. And for 2 years, one of the legal associations was actually funded to just train. And they went out and they trained social workers, and they trained teachers, and they trained doctors, and they trained anybody who wanted to know how to work with refugee children, within the legal framework. That's what they did. And so I think it's about creating that movement and where the interest is. And there are enough people, I think, in this room who've got expertise who would want to share it. And I think also it comes back to my sort of starting point is not to think in silos, like I only work with children in this area, or I only work with children in that area. And we just start to think children are children. Children, certainly for us, it's child first, migrant second, but always thinking that everyone has something that they can add, and really that's how you grow this work. And then you get best practice, and then best practice becomes law, or it becomes statutory. So in Scotland, if I give an example, guardianship for unaccompanied asylum-seeking children, that was like a pie-in-the-sky idea that we used to talk about a decade ago. I used to be in those meetings where we say, wouldn't it be amazing if kids can have guardians to help them all the way through the system, that they can work with social workers, work with teachers, work with their psychologists, work in the courts. And, a decade on, it's now statutory. It's now there is a duty on social work departments to refer to the guardianship system. So it's kind of one of those things that you can have a good idea and think, you know, this isn't going to go anywhere. And I felt very inspired this morning actually hearing the keynote about, you know, if your idea seems like a crazy pie in the sky idea, well, there's nothing to lose in trying it. And I think it's identifying enough people who share in that idea. And I think this is really the beginning. You know, I felt very excited to be here this morning because I felt that, you know, I'm in a room with everyone that has this passion for really, you know, driving the child rights agenda in Hong Kong, because we're very lucky that we have the convention, and there's so much that we can do with it. So that's what I would say is how you begin to systematize by actually starting the movement.
Thank you, Pia. Jessica?
Yeah, actually, first I'll just second something that Pia said, just for emphasis. Your point, Pia, about all of us sort of thinking, you know, we only work with one particular population of children, or, you know, for example, I specialize in working with children and adolescents who are child welfare and juvenile justice involved, but it's really important that we all recognize that we have to work with all populations of children, and that these are really the same children and families. They may have a different set of circumstances, but they're essentially the same set of children and families. And I often see, because I do work with children who are juvenile justice involved, that there is a lot of discrimination against them. And, you know, we think of social workers as being some of the most compassionate people in the world, and I think many of us are. But I even see within the social work field that there are many social workers who don't want to work with children who have been accused of a crime or who have been convicted of a crime. And it's really important that we be able to work with all children and families. So I want to second that. And then I would just also add a couple of points. One thing I would say is that I'm not sure it's even always beneficial to have everyone at the table, because I think that can be really overwhelming to a child or an adolescent. Often it ends up feeling like there's an interrogation going on, or it often feels like there are so many adults who are deciding my best interests, as opposed to asking me what I want or what I expect as the outcome, or am hoping to achieve. So that's just one piece I would say. You know, of course it is important to have as many people as we can who specialize in different areas, but I think we want to be careful about bringing them all to the table when they're with the child especially, and also just reminding folks that it's really important that we do honor what children and adolescents view as the problematic circumstances for them and what their wishes are. And then the last point I would add is just really about humility. I think all of us who have been working in the field for some time, you know, we tend to think of ourselves as experts in a certain area, and perhaps we are experts in one certain area or two certain areas, but really doing multidisciplinary work or interdisciplinary work is about recognizing that there are limitations to every discipline, and that we can't always have every single skill set or every single form of disciplinary knowledge, and that really recognizing that and being humble about that and honoring the fact that other disciplines have something really important to bring to the table is really key. And sort of just acknowledging that working together and collaborating together and learning about each other's skills and about each other's discipline and how we can get better at our own practice is actually really advancing the goal of, you know, honoring the full well-being and rights of children. And the last point that I would just say is, this is going to sound a bit silly, but I actually joke with my students that they should carry around the Convention of the Rights of the Child in their pocket. And I mean it as a joke, but really what I mean is that we can never be sort of too familiar with that document, or we can never look at that document often enough. It's good to sort of put it in a place where you look at it often, or pull it out often, or whatever you need to do to refresh your recollection and to look at the areas of the convention that perhaps you are starting to forget about and you want to remind yourself of, or that you're not emphasizing enough.
Thank you so much, Jessica. I think two things that really sort of stand out to me are, first of all, the idea that we cannot afford to dehumanize anybody who we work with. And one of the risks of systematizing things is often we fall into that pattern where people become cases or case numbers, or, labels sort of dominate our understanding of who we're dealing with. And it's so important to move away from that. And so I think it's a fantastic idea, right, to make sure that we're always refreshed in terms of what are the values that are going to guide me as I go about doing my professional work today. And it doesn't hurt to have something displayed in a prominent place, especially around your desk, if we're committed to securing and ensuring that we're empowering the people that we work with. And the second, I think, very, very important point that both of you brought up really is humility. Right, and there's no way to do effective multidisciplinary work unless we recognize, and the reason to do it really is because we recognize our own individual shortcomings as professionals engaged and immersed in a particular sector. And there's no harm. In fact, it can only enrich the outcomes that we develop if we're willing to accept that there are limits to what we can do and to let somebody else in and help us co-create effective solutions together. I really would like to spend at least 5 minutes, because it's been quite a one-way sort of morning, to give you all an opportunity, and I don't think 5 minutes would do justice, but really to sort of have a little bit of a dialogue here in case there are questions that have emerged. So I'm going to take 3 questions in one go, and then I'm going to ask our panelists to respond, and then we'll move to lunch then. So 3 questions. Please identify yourself and your affiliation if you're comfortable, and then ask your question and keep it brief. Thank you. Questions?
Hi, my name is Cliff Emery. I'm an associate professor at Yonsei University in Seoul. And I've spent probably about a quarter of the last 7 years in Beijing, and sort of looking at how you can study and do child protection in mainland China. And the sort of elephant in that room, and what sort of keeps striking me as we discuss this, is even bringing up the concept of rights in mainland China is, just sort of produces this visceral response of, uh-oh, we're on shaky territory. And I'm, being the sort of pain in the backside that I generally try to be, I've been thinking about how can we kind of, in that context, persuade people, kind of move child protection forward in that context when a rights framework is so tenuous. So I'm going to throw this out, and I have no idea what the consequence will be or whether it will work at all. But what do you think about the idea of pushing universal obligations in that kind of context? If you look at some of the things that the PRC has been doing with respect to family welfare, they've been trying some things which I don't always agree with, but things like trying to force adult children to visit their parents, their elderly parents, at least once a year, and if they don't, there's going to be some kind of consequence. That kind of speaks to the existence of the idea of obligation, and I wonder if that could bypass some of the baggage associated with rights. Thank you so much for everything.
Are there any other questions that we can take at this time? Okay.
Wow.
It's open to both of you if you want to answer that question. Pia, would you like to, or Jessica?
Sure.
I guess I would say in the United States, we have a lot of pushback against a rights-based perspective as well, which of course is getting worse more recently for
Talk about elephant in the room.
a certain reason I will not say the name of, because I don't like to use his name. But yeah, there's a tremendous amount of pushback. I get it all the time, especially I think around children, recognizing that children have rights. We like to think that adults know best, and that children, although they're human beings, sort of are not full human beings yet because they're not adults yet. So there is a tremendous amount of pushback. I don't know that I really have the answer to your question, but I would say that I definitely like your idea of talking about obligations, because, and I might start using that language more now, so thank you for the suggestion. Because really it is about accountability, I think, and about holding not just those who have more power than us accountable, but holding ourselves accountable as well, and recognizing the obligations that we individually have. And I think it starts with each of us as individuals and to sort of role model that for others and perhaps to point out that we're role modeling it if we need to. But I really like the idea of using that language. I think when I get that pushback in the United States, of course I acknowledge it, but to me, it's really just about, again, highlighting that children are already human beings. They don't need to be adults to be human beings. It's really, for me, about repetition and having patience with people who don't necessarily see the value of children's rights or rights for children. But again, I really liked your suggestion, and I think I'm going to start incorporating that more, so thank you.
Okay, if I can just jump in, I'm going to say the opposite, actually, which is I think in the US it's difficult because they haven't ratified the convention, but in Hong Kong it is ratified. And so if we start to not talk about rights and talk about obligations and talk about the fact that government has signed these things, that's when you start to weaken actually the kind of, well, what's the point of it? It's like a piece of international law that sounds nice and that we've got it, we can claim to have signed it, but we're not accountable for it. So, and you're right, and I think it is very challenging where using it can be difficult, but it, as a lawyer, I would say we can't stop using it, and that's where we have to use international mechanisms, and that's part of an advocacy policy piece, because governments do have to account for their every several years they have to say how they're doing against these mechanisms, and it's really kind of important for everyone, certainly in civil society, to understand that these are obligations that government signed up to. They're not voluntary, and they're kind of not they can't just pick and choose. If they wanted to do that, they should have expressly said that. And so I would actually, counsel, certainly in Hong Kong, we don't work in China, in mainland China, but certainly in Hong Kong, we have rule of law here, and we have institutions, and if we start to move away from this, then, I can see we're weakening, we're weakening what we have for no reason, because we've got a mechanism in which we can challenge, we can cite the CRC in cases. It may not be done in practice, but it's always there to do it. And I think it's always, certainly from a policy and advocacy perspective, we always have to bear in mind that governments are accountable, and that's certainly in the international community that they're accountable. And so, I think, I understand the difficulties you must face in trying to do your work. And yes, it is about it depends on your audience as well, right? I think it's where are you and who are you speaking with, and and who else is in that room. But certainly when there's higher level kind of audiences, we can't move, we shouldn't move away from talking about these as express rights that we're signed up to. So that's... Yeah. Yeah.
So if I may, I might jump in, although I'm not sure if that was directed at me, Cliff. But, language is so important. Jessica alluded to this earlier, that there's this notion of universal rights and cultural relativism. But I really worry about the challenges of seeing them as ands. I recognize, and it's important, I think, to talk about both and how they interrelate, but it could be very dangerous in certain parts of the world, and particularly with our regional context, to start talking about cultural relativism, to walk back some of the rights that have already been internationally agreed as universal. And what I found to be more constructive, at least in the work that I've done with minority groups, is, it's always possible to reach within a community context or within cultural frames to devise language that is acceptable. Oftentimes you'll find it's not the notion of a right that's challenged, it's how you frame the issue that is being challenged. And so if you can just walk away from the discourse that is seen as having this, hierarchical power dynamic because these are Western values or whatever the reason might be, to reject rights and then adopt a different language, but without undermining the substance of what we're after, I think then we're co-creating a new understanding. And then we can devise constructs or concepts which are relevant, right? Because you're seeing as having been part of that conversation, which is what I understand the cultural relativism debate to be about. It's, we weren't at the table, or, many of us were colonized at the time that you drafted these principles, so we don't sign off on these, we reject. But if you look at the instruments that we do have and the understandings that we have within the region, we're not too far off. It's just how do you activate or practically realize these in a real sort of sense. On the notion of obligations, I really worry because if you look at law, so for example, we have a lot of anti-discrimination legislation. That doesn't necessarily mean that we've achieved in our society any level of the kind of acceptance and inclusion that we want to see. We use the discourse of tolerance, which is very problematic because there is a power dynamic implicit in sort of organizing our conversation in those terms. So I think law has its limits. It's an aspirational sort of standard. Some people say it's an ideal standard or idealistic standard, but there has to be a co-organizing sort of an incentivizing framework from the bottom. And I think that really comes down to maybe drawing inspiration from Dave's talk, that, we're dealing with human beings and human nature, and we have an inherent capacity to either sort of, focus on the negative and then force people to comply. That's the language of the law, the stick. And that's good, you need that. But at the same time, you also have to, harness people's capacity for compassion and good and allow there to be, a development of an expectation that our standards as humanity can be set this high. We have a natural compulsion to gravitate towards doing things which are satisfying for their own sake. We don't have to be paid in order to do what is right. We can govern ourselves to do the right thing, if we rise to that. So I know it sounds a bit fluffy and out there, but I think we need to have both, right? You need the stick, but you also want the carrot, and, people will do these things for a variety of reasons. And we have to rely on a personal sort of ethical and moral compass as well. And if anything, I think that's where we're probably falling short at the moment, as a world, as a global community, right? In every part of the world, we recognize that we're not necessarily living in the way that we ought to. So we can focus on sort of a more ethical development of children, but also adults, and to sort of be reminded constantly of what our obligations are to each other outside of the law. And then also, to have a professional charter. So we've all got, codes of conduct, but I think that it doesn't hurt to come back to what the expectation is of each sector for each other. So an interdisciplinary conversation about, I think lawyers should, or I think social workers should, and then to sort of integrate that into our own expectations of each other in the field when we encounter each other, and hopefully work towards a more, raising the bar for each other. So you don't need the law as a check on people to do the right thing. We're there as checks on each other to call the other person out and say, this is a human being. You ought to be doing more. I think you can do more. But that really involves us, at least in these fora and in others, to push each other further. I want to pick up on something else that both Pia and Jessica mentioned, and that is that, this conference serves as a platform to exactly have this kind of conversation, which we wouldn't be able to have in every single case where we get around the table. So in that vein, I want to share with you that Mother's Choice and CCPL has worked over the past year and a half together to put together a child rights manual, which is available online, and someone's going to be putting up a slide to show you, or I think there's also a link in your conference booklet, where we've gone through some of the steps to think about, what is the state of knowledge and what needs to be understood, and what kind of skills can we sort of bring to the fore to encourage people to build their capacities further when they work with children. So we hope that it'll serve as a useful document. There's also a breakout session dedicated to using the manual, which you can sort of go to at lunchtime. So I encourage all of you to please download the manual, take a look at it, come and share your feedback with us so that we can continue to work on it. It's a work in progress, but the first sort of finalized draft is up there for you to sort of draw on. So now I'm going to close sort of the morning session. We've got lunch, which is available at the podium. You can pick up your lunch and go directly to your breakout sessions to work on for the afternoon. And then we'll reconvene back in this venue at 2:45. Enjoy your lunch and learn. Thank you so much. Please join me in thanking our speakers this morning.